Hello, this is Steve Cara. We're here today with Walter Weber from the American Center for Law and Justice. Thank you for being here today, Walter.
My pleasure.
I just want to start by asking you a quick question. There's people in Michigan who are concerned that if we do a heartbeat bill, that it could possibly compromise existing law in the books. Is that a concern that people should have? What do you think, and is there a way that the heartbeat bill has been written in order to make sure that we protect the existing laws Michigan already has?
Right. You certainly want to take whatever steps you can not to undo good things you have. The Michigan heartbeat bill, as it's currently drafted, is not a problem in that regard in any respect for two main reasons. One is that under Michigan law, something called a repeal by implication is disfavored. What's a repeal by implication? It means when you're not passing a bill that says law X is repealed, you're instead passing a law which is so incompatible with the previous bill that it seems to suggest that you have intended to repeal the previous bill. And because that's a judgment call, the Michigan Supreme Court and lower state courts in Michigan have said repeatedly that repeals by implication are not favored. That is to say, we assume that the laws that are already on the books stay on the books unless you're really, really clear that you want the new law to supersede the old law. That's number one reason why the Michigan heartbeat bill is not a problem for repealing existing law. Number two is that the bill itself says this bill does not repeal any existing ban on abortion, like three different ways in the language.
Yes, one of which was a recommendation from you. I believe I have it memorized by this point. Nothing in this act shall be construed as authorizing any abortion that's illegal under any other provision of state law. Very clear, very straightforward, and like you said, it said two other ways explicitly, including not to compromise the MCL 750.14, which is the abortion ban in Michigan currently. So with all that said, I guess lawyers, from my understanding, they tend to not give a 100% certainty for anything. They often will say something to that extent. So, you could take it from telling somebody, well, I can't be 100% certain, to somebody else saying, oh, this could compromise the abortion ban, to eventually down the road, some people are misconstruing that and saying this would compromise the abortion ban. So it goes from in my life, I might end up dating Kate Upton someday, right? Is it in the cards for me? I doubt it. It's not going to happen. But could it happen? Technically, yes. But does that make sense? How it's like something that could happen, but it's all like a 1 in a million chance. And would it take the heartbeat bill, or could they use something else if a judge wanted to in order to compromise the abortion ban on the books?
Okay. Well, part of the problem, as all of us in the pro-life movement realize, is that judges sometimes act as activists. I mean, the Roe versus Wade decision itself is essentially made up. There's no reference to abortion in the Constitution, and yet you had a majority of the Supreme Court saying that there was a constitutional right to abortion under the 14th Amendment, even though there's nothing there to give a clue in that regard. So could an activist judge come up with some excuse for saying that a subsequent law repeals a previous law? Yes. I mean, if they're willing to defy the law to that extent, ignore the existing Michigan case law, ignore the language in the statute, then in that case, they're not going to need much of an excuse to do that with existing law, whether it's a ban on partial birth abortion or a new law on dismemberment abortions or informed consent or whatever it is. If that's their mindset, then you can't stop a judge like that, and that's why you need, of course, good judges. But as far as sure as you can be with the existing case law, the way that the Michigan heartbeat bill is written is to go along with the landscape that exists currently in the state, which again is that you don't assume that a new law replaces existing law unless it's really, really clear, and here there's no reason to draw that conclusion. Quite the contrary, the law says itself, this is not repealing any existing bans on abortion.
Correct, yes. And so I guess if somebody was to come to me and say, Steve, I don't support this bill because I have these concerns, what should I tell them? How do we ensure the people in Michigan that what they're hearing is not something that should be a concern? I mean, obviously, when we're saying a certain thing and other pro-life people with good intentions are saying something different, I guess why do you think that is?
Well, I just say that what else could you do? I mean, if the law says you assume the existing laws stay in effect, and if the law that you're adopting says this isn't meant to change any existing law, there's really nothing else you can do. That's as sure as you can be.
Right.
that shouldn't be a problem.
Right, and so the partial birth abortion ban that we already have in law in Michigan, as well as the dismemberment that's being proposed as well, they have strong savings clauses in it as well, as we mentioned earlier. So those protections have been used before, and they've been used this time as well. So each step of the way, I think that the pro-life activists have taken those necessary precautions. But like you said, you can never guarantee that a rogue judge might be an activist and might compromise something that would be egregious. But they all should be protected.
And Steve, the other thing to remember, it's for us lawyers, it's more familiar, the idea that the same act can be illegal in a lot of different ways. For example, suppose you have a law on vehicular homicide, right? People getting killed because of the negligent operation or reckless operation of a vehicle. Well, the fact that you have that law does not mean that it's okay to kill people if you don't use a car.
Mm-hmm.
Right? You can prohibit a specific form of a crime while leaving all the other bans against that crime untouched.
So you're saying that there would not be conflict if you have one law that says something and you have another pro-life law that says something further or in a different way. Those are all pro-life laws and they're not conflicting.
They're just overlapping prohibitions of the same act.
Overlapping, that's a good way of putting it, yeah. Okay, so another question would be, if Roe versus Wade is completely overturned, that would be ideal. You know, there's a good chance that they'll chip away at it, like Brown versus Board of Education chipped away at Plessy versus Ferguson, and then, you know, they continue to get better and better afterwards. So if we are fortunate enough to just outright immediately overturn Roe versus Wade, what would the process be for Michigan by that point? Would the abortion ban on the books immediately be enforced, or would it be something that are there steps that would need to be taken before that abortion ban would be the law of the land in Michigan?
Okay, that requires a little bit of a complicated answer, and I'll try to break it out into pieces. Okay, you have this law in Michigan that bans all abortions. The state Supreme Court has interpreted the law narrowly. When Roe versus Wade came along and said there's a right to abortion, that obviously created an obstacle to the enforceability of the existing Michigan law banning abortion. So what the state Supreme Court of Michigan did in a case called People versus Bricker was say, we're going to reinterpret the Michigan statute to be enforceable insofar as Roe versus Wade lets us, which means that if you're not a doctor, for example, which was the Bricker case, doing an abortion, that can still be illegal. If you're doing an abortion after viability and you don't have an important health reason to do the abortion, that can still be illegal. So what you have is a statute that says it bans all abortions, but is being interpreted to apply within the space that's available under Roe versus Wade. Now, if the Supreme Court comes along, U.S. Supreme Court, and overturns Roe versus Wade, or modifies Roe versus Wade, or retracts Roe versus Wade, does something that allows more abortions to be prohibited, and then suppose your local prosecutor then starts charging someone for doing the things which had been protected before the modification, but now are not protected. Well, the abortionist is going to say, hey, I was doing stuff that was legal under Roe. There's been no change in the law, and there's been no word from the state Supreme Court that this is now prohibited, so it's unfair to prosecute me. Now, I don't know whether that argument would win or not, but what I'm saying is it would make it more difficult than if you had a law on the books already that said, if you do X, Y, Z, you can't. So if you have a law that says you can't do abortions by dismemberment or after heartbeat or by partial birth, that is a specific prohibition which puts the practitioners on notice. The Supreme Court issues a decision saying that those kinds of laws are constitutional. At that point, you just put one and one together, and you may have to go into court to get a declaration. You may get an opinion from an attorney general. You may have an announcement from a local prosecutor. Whatever you have, you're saying, we have the pieces in place. We have the law that says you can't do this. We have a Supreme Court case saying it's okay to prohibit that. You got to stop. That's a much easier case to make than saying, we have a law that bans all abortions, and we're interpreting this to now give us the room to do this, and we're going to use that existing law to prosecute you. You may be able to do that. But I'm saying it's less certain than if you have a law specifically prohibiting the act.
So just to reiterate that, there's no guarantee that if Roe versus Wade is completely overturned, that Michigan's going to have a law on the books that is going to be enforced. There's no guarantee that that's exactly
no guarantee, right? Yes, it would be nice if that happened, but that would require the cooperation of the Michigan Supreme Court, and you'd also have to have prosecutors willing to make the steps to set that up.
It would, although it is fully enforceable, it'd be nice if we could snap our fingers and it automatically would be fully enforced.
Right.
But we don't have that guarantee. Just a hypothetical question, would you say that there's a greater chance that the heartbeat bill does not compromise existing law, or would you say that there's a greater chance that the abortion ban, the MCL 750.14 that Michigan has, would end up being fully enforced if Roe versus Wade's overturned? Which one's more likely?
I'm fully confident that the heartbeat bill does not compromise in any way the existing abortion ban.
Okay.
As far as the enforceability of the existing law, if Roe versus Wade were explicitly overturned, I would not know where to put that percentage, because it would depend a lot on who's on the Michigan Supreme Court at the time.
Right, and hopefully that's a high number, but we just don't have that.
I would like to
guarantee.
think it's a high number, but I would feel much less confident in putting a number on it.
Yep, okay. Well, sounds good. Thank you very much, Walter.
Glad to help.